Hi there, it's Jessica. Today I wanted to talk to you a little bit about how to prepare for your first family court hearing. This is a super stressful time. I totally get it. I mean, it's stressful for participants. It's stressful for lawyers, if you can believe that. Um, it's just all around a bit nerve-wracking and hard to get used to. So today, I want to walk you through exactly what to expect, what you're going to want to bring with you, and how to prepare so that you feel confident when you step into that courtroom. Whether you're self-representing or you just want to be more prepared, this video is going to help you feel in control. Family court's not like what you see on TV, especially if you compare between Canadian and American versions of courtrooms and whatnot. It's a very structured process, and the better prepared you are, the smoother it's going to go. I am going to cover everything from gathering the right documents to courtroom etiquette, so stick with me to the end. Let's get started. First of all, you want to make sure that you understand the purpose of your hearing. Not all family court hearings are the same. Your hearing might be a case conference, a motion, or even a trial management conference, and each of those serves a different purpose. So knowing what to expect is going to be key to this. Here's a quick breakdown. You have hearings called case conferences. These are informal discussions that where the point is to settle issues before the whole thing goes to trial. So in a case conference, the judge might give their opinion on the case and encourage you and the other party towards a resolution, but there's not going to be a final decision made. You're not going to be making any legal arguments yet, so you're going to want to focus on presenting your concerns clearly and concisely. Now, if you're asking for something specific, you might have a motion hearing scheduled. So if you're asking for something like child support, spousal support, or a temporary custody order, you're going to need to explain your request and provide evidence to support that request. That's where being prepared is crucial because the judge is going to make a ruling based on what's presented in that motion. So if you're missing documents or if you're all over the place and the judge can't really follow what you're saying, that's going to be detrimental to you. You may also have something that's called a trial management conference. That's a planning session before trial. During this conference, the judge is going to ensure that both you and the other side are ready. They're going to discuss what evidence is going to be presented. And again, they may attempt to resolve some outstanding issues before trial. That's a really big push in the family court system right now, is to get as much of it resolved outside of court and before trial as possible. So again, having an organized case can keep that process moving along very smoothly and you feeling in control. Quick tip, you can call the court ahead of time or check online resources to confirm the exact nature of your hearing if you're not sure what it is, so that you can prepare accordingly. Step 2, you're going to want to gather your documents. Judges expect you to be prepared. So you'll hear me harp on organization over and over and over again, but that's for a reason. The judge expects you to be prepared, whether you're a lawyer or not. If you're missing documents, you can slow your case down or you can even hurt your credibility. That means you can hurt whether the judge believes what you are saying if it's coming down to that. Here are some of the things that you should bring. So first, you want to bring your application or response forms. Now, those are the main documents that state your case. You want to make sure that they're signed and that they're properly filed with the court before your hearing. The next thing that you want to make sure you have, the second thing here, is financial disclosure documents. If your case involves child support or spousal support, you'll need pay stubs, tax returns, bank statements, any proof of major expenses for the children or for yourself. My previous video discusses financial disclosure documents more in detail. So if you want to go back and look at that for some more information there, go ahead. The third thing you want to make sure you have is any past court orders. So if there have been previous rulings or orders, the judge is going to need those so that they can understand the history of your case. Don't assume that the judge has any of that information ahead of time. You want to make sure that you have it in your documents and that you're presenting it. The fourth thing you want to do is have a summary of your key points. And, assuming it's not a really long, like several day trial, have a one-page summary of the key facts and what you're asking for. This is going to help you stay on track when you're speaking. This is more a document to have on hand for you to keep you organized and on track, especially if you're starting to feel a little bit nervous. It gives you something to look back at and figure out where you are, what you want to say next. Do not worry about taking pauses if you find yourself a little bit lost or flustered. Feel free to look down at your summary of key points, figure out where you're at, and formulate what you want to say next. And then the fifth thing you want to make sure you have is evidence that supports your claims. So for instance, if you're arguing for a parenting arrangement, bring school reports, bring communication logs, so text messages, emails, phone calls between you and anybody relevant, particularly your ex, or any other supporting evidence that are going to back up your position. Another tip here, organize everything in a labeled binder with tabs and a table at the front so that you can find your documents quickly when you need to. And again, I have available, and I'll try and link it below here, a court document organizer PDF that you can download and that you can use to keep yourself organized during that court case. Step 3, and this is really important, and if you're anything like me, I hate doing stuff like this. Like, it makes me feel really uncomfortable. But step 3 is practice what you want to say, like in front of a mirror or in front of a friend or somebody that you trust. But you just need to remember, self-representing does not mean winging it. You want to be just as or even more organized than any lawyer would be in that courtroom. You need to take the time to practice your key points. You want to keep your statements short, clear, and fact-based. Judges don't want long personal stories. They want the relevant facts. So the more you can keep it to the facts and keep it really concise, the better off you're going to be. You definitely don't want to say things like, my ex is a terrible parent and never listens to me. You do not want to be overly critical of your ex. Of course, if there are concerns and you have evidence of those concerns, bring them up. A way to say it instead of, my ex sucks and they never listen to me is, the other parent has missed 6 scheduled visits in the last 3 months, which have negatively impacted our child's routine. This way, you're achieving the same goal in that you're telling the judge, this person hasn't been necessarily very responsible, but you don't want to come off as being aggressive, judgmental, that sort of thing. You want to just give the judge those facts and let the judge draw his or her own conclusions from that. So practice in front of a mirror, practice recording yourself, because then you can go back and watch it and really critique, like, I don't like the way I said that. I don't like the way that this came off. Or have a friend listen to you. These things can help you feel more comfortable speaking in court. Another tip, judges appreciate when self-represented litigants are concise, respectful, and prepared, just like we talked about. If you get emotional or off track, take a deep breath, refocus on your key points. So like I said, take a deep breath, look down at your summary, find out where you are, ground yourself, take a breath, formulate what you want to say next. Step 4, know your courtroom etiquette. You don't need to be a lawyer to know how to speak in court. You don't need to be a lawyer to make a good impression. You just want to follow these simple rules. First one, get there early. You want to be there at least half an hour before your hearing, because that's going to give you time to find the right courtroom, to review your notes a couple of times, and to take some breaths and calm down. The second thing you want to make sure you do is dress professionally. Business casual or formal is best. You definitely don't want to wear jeans, hats, ripped clothing, sleeveless clothing. Dressing appropriately shows respect for the court, and as old-fashioned as it may or may not be, the judge is going to expect to see you appropriately attired. The third thing you want to remember to do is to address the judge properly. You will have to figure out whether you are in provincial court, or if you're in Alberta, Court of King's Bench, or if you're in BC Supreme Court. If you're in provincial court, you want to refer to the judge as Your Honor. If you are in Supreme Court or Court of King's Bench in Alberta, you want to address the judge, depending on whether they are male or female, as my lord or my lady. Now, if you're unsure how to address someone, you can watch if there are other lawyers in the courtroom about how to do it. You can, even at the very beginning of your hearing, you can ask the judge themselves and say, excuse me, I want to make sure that I'm addressing you appropriately. Could you remind me whether I refer to you as Your Honor or something else? That's totally fine. The fourth thing you want to do is stay calm and composed. Even if, and especially if, the other party says something upsetting, don't interrupt. Trust me. The less that you get involved in how the other side is behaving, and the less that you let how the other side is behaving affect you, the better off you are. You are going to make a far better impression if you are able to stay calm and composed, even if the other side is flying off the handle or accusing you of things that aren't true, whatever it may be. Don't let them rile you up. You want to wait for your turn to speak, and you definitely never, ever want to argue with your judge. Okay, so the fifth thing you want to remember about courtroom etiquette is to follow courtroom procedures. Again, it's a formal setting. It may feel weird or old-fashioned, but you want to make sure that you stand when you're speaking, you sit when you're asked to, and that you only address the judge unless you're asked specifically to respond to the other party. You don't address your ex or their lawyer. You address the judge unless you are specifically requested to address somebody else. Another tip here, watch a family court session ahead of time. And I don't mean on TV, but find a family court session at the courthouse closest to you that is allowing public access to see how hearings are conducted. Sit through a couple even until you get a good sense of what these things look like. It'll make you feel much less nervous, much better, and you'll already have some of those things in your mind in terms of what etiquette is going to be expected of you. Okay, and then step 5, prepare for the unexpected. Sometimes things aren't going to go exactly as you plan, so you want to be ready for any number of things, but a few things I want to call out specifically are adjournments. And this means if the judge isn't ready to give a ruling or order on that day, they may schedule another date. And that can be super frustrating, but it's very common in family court. The next thing that you want to be prepared for are unexpected questions. You want to stay calm, take a breath, and answer clearly. So if the judge or the other side asks you a question that you really weren't expecting and you don't have a prepared answer for, it's okay. Just gather your thoughts, take a breath, answer when you've got something formulated. And if you don't know the answer, it is completely okay to say, I don't have that information right now, but I can provide it later. That's absolutely acceptable. Don't make something up. If there's information that you don't know or you don't have on you, you can say that you don't know or you don't have that information. And then the third thing I want you to note is that you may get a ruling that you didn't expect or don't agree with. So you're not always going to get the ruling that you wanted. If this happens, you want to ask the judge what your next steps are. You may be able to appeal the decision or file additional paperwork, but you want to be prepared to get an order that you didn't want. Maybe the judge is siding with your ex and it's upsetting to you, which is understandable, but you want to remain calm and polite in court, ask the judge the next steps, and then act accordingly after that. Tip here, be flexible, stay focused on the bigger picture. Getting the best possible outcome for your situation is your main goal. So you've got those 5 steps. Let's just summarize them very quickly. The first one was you want to understand the purpose of your hearing. The second one was to make sure that you gather your documents. And remember, I do have that document organizer available for download. You want to practice what you want to say in front of a mirror, in a recording, in front of a friend. You want to make sure you know your courtroom etiquette. So stop in to a public family court session and check out what they're talking about, how they're talking. And then step 5 was to prepare for the unexpected, things that you really weren't expecting to happen, and try to remind yourself to stay calm and focused in those situations. So I hope you're feeling more prepared. Again, family court can be really overwhelming, but you do not have to do it alone. If you need help organizing your case or preparing for court, I offer virtual legal information sessions to guide you through that process. So your next steps are going to be to download my free family court document organizer. You're going to find that link in the description. Next step, you can book a free 15-minute strategy call with me to make sure that you're ready. I'll have my booking link below as well. And then you can subscribe for more self-representation tips. I'm going to try posting new videos at least every week with more tips on how to represent yourself in family court. And I would love to hear from you. You can drop a comment below if you found this helpful. I want to thank you for watching, and I'm going to see you in the next video.